Give thanks and praise to the mystic laws of the universe and its protective functions and forces in nature that guide our thoughts and our path in all ways that are lawful, correct, and positive. Give thanks and praise. United States versus HERRERA. We have the Nantucket State Trooper Bates. Just pay attention. Just pay attention. Sometimes we have to entertain ourselves, because that is only natural. But we have to get back to the task at hand, and that is a man such as I continuing to share in information, pertinent information. So we got, take time, chop up the court case here.
United States v. HERRERA. United States Court of Appeals, 10th Circuit. United States of America, Plaintiff-Appellee, v. Robert J. HERRERA, Defendant-Appellant. Number 05-3057. Decided, April 19, 2006. Before Henry, McKay, and Ebel, Circuit Judges. Michael J. Gunter of Clayman and Gunter, Kansas City, Missouri, for Defendant-Appellant Robert J. HERRERA. Eric F. Melgren, United States Attorney, and Tristram W. Hunt, Special Assistant United States Attorney, Kansas City, Kansas, for Plaintiff-Appellee United States of America. A Kansas state trooper pulled over Defendant-Appellant Robert J. HERRERA to inspect HERRERA's pickup truck pursuant to a Kansas regulatory scheme that permits random inspections of certain commercial vehicles. HERRERA's truck, however, was not a commercial vehicle subject to such inspections. Although
HERRERA's truck, however, was not a commercial vehicle subject to such inspection. Pay attention.
Although the Fourth Amendment allows warrantless administrative inspections of pervasively regulated businesses in some instances, the validity of such an inspection is premised on the regulatory scheme giving notice to the members of the class of affected individuals that they are subject to such an inspection.
All right. They keep using the word regulatory scheme. And right here, them say Kansas regulatory scheme that permits random inspection of certain commercial vehicles. So if we remove the word Kansas and put Nantucket, we would have Nantucket regulatory scheme that permits random inspection of certain commercial vehicle. So even with the Nantucket regulatory scheme, they are only permitted to inspect commercial vehicles. We just want to get to that point there. So them have a scheme. And what is a scheme? The very same thing as a scam. Do the research. Remember, we had a national housing scheme that has been renamed to Housing Trust. We have to ascertain the legal definition of these words being used. And this is a federal case. adjudicated fact, we would call it. And federal mean it goes straight across the board. Only because if you find yourself being married in Jamaica and you go to any one of these federal locations, you'll still consider being married. Yeah, man. So the moment you have a commercial vehicle out there, then it's subjected to regulatory scheme by any probably corporate entities. Once you're engaged in commerce. Now, the moment you're outside of commerce, then none of these things apply. Absolutely none. It's just a waste of time, and then you'll have to charge them for the time we waste.
United States Court of Appeals, 10th. United States, decide before Henry.
Let me get back to where I was. No, I forgot back through all of these things. Yeah, man, I have to start it from here so again.
A Kansas state trooper pulled over defendant-appellant Robert J. Herrera to inspect Herrera's pickup truck pursuant to a Kansas regulatory scheme that
Pursuant to a Kansas regulatory scheme that permits random inspection of certain commercial vehicles. Pursuant to a Nantucket regulatory scheme
that permits random inspections of certain commercial vehicles. Herrera's truck, however, was not a commercial vehicle subject to such inspections. Although the Fourth Amendment allows warrantless administrative inspections of pervasively regulated businesses in some instances, the validity of such an inspection is premised on the regulatory scheme giving notice to the members of the class of affected individuals that they are subject to such an inspection.
You hear that? Although the Fourth Amendment allows warrantless administrative inspections of pervasively regulated businesses in some instances, the validity, again, the validity of such an inspection is premised on the regulatory scheme, giving notice to the members of the class of affected individuals that are subject to such an inspection. Again, giving notice to the members of the class of affected individuals. So my brethren Joel Jaguar now fall under that class. And this is where we talk about. So some people have things on paper and other people are try, I agree with them. I say, boy, because it's on paper, then, it's law. We are rebut everything. Every single thing we are rebut. This is why we take exception to commerce, high people. So when we use commerce, them say it's too high. If we use material world. I like use commerce because people have to learn these phrases. They have to learn these legal terms. They have to know the definition of these things. And the moment you engage in commerce, you're going to know say it's one of them kind of thing that where them call it a regulatory scheme. You understand? It's a scheme. So from a day in a commerce, you're subject to these kind of, inspections. The moment you're outside of commerce, none of these things apply. We can't break it down no simpler than that. So we are take it step by step. And we are use adjudicated fact to demonstrate these things. Because my people fixated on this bag of paper, when all you have to do is write on paper say you're free. Write on paper say show me the contract with me and you have, what we agree to. Don't tell me you have a one-sided thing where you set in place and I should subject myself to the will of whatever is on that paper where I didn't agree with. These are the things that we are talking about. It's basic. You understand? So this is why we want to bring up people from that basic level to, from that base state, to bring them to this basic level. This is what it is about. This is our focus. Now get carried away with the craziness where Babylon create out there. Because Babylon create a set of people. Babylon create the people where you see a cause all of the craziness. Now for them young ones, you ask her when them born. What year them born? In a what? 2000? 2001, 2002, 2003. What was the environment like? So why we surprised when we see the atrocities we are going? A man like me can't cry out and say I'm surprised. A man like I tell the eye them say it gonna get worse. Because people only pay attention to the effect and them now look at the cause. The cause is still there. So we say truth supreme. If you don't have truth, go one side. And when you lack knowledge, go sit down in one corner and learn. And them thing that we are saying. Why? Because of that we do. If we don't have truth, we go and we go one side because we don't have it. And if we lack knowledge, we go sit down in one corner so we can learn. But that's the problem with most of our people. We become so egotistical, we don't even know what the ego is anymore. We use words sparingly now. You understand? But through me know a stages and a step by step. We're going to stay resolute in this pursuit of freedom, freedom in and freedom in. And the expression of such. And we now forgot through phone law school or legal school for attain these kind of information. And we now forget to have them information here. We now feel attached to a secret society to break down them kind of information here. So this is where we are. We are say, look, and we write this, and we, we are said at this documented as fact of law, facts and conclusion of law. But we have a set of people who choose to ignore law and do their own thing until they get caught. And most of our people excuse these people for whatever reasons. We excuse them when them are not us. Our people alone we can excuse. Our people lack the knowledge just like us. But these other people are them bring this thing here. So we can't excuse them. We have to give them the opportunity to be honorable. And when them choose not to be, then them are move with unclean hand by their own laws. Because them have them laws in place for such actions. So all you have to do is point out their actions, their omissions, their commissions. And so shall they be judged out there. What kind of Mickey Mouse back and forth game people are trying to teach we how to play? When them now express to it how to stand up as free man, because I don't have a clue. And me now say me know, I just know say boy watch ya, this is my stand. If the Most High create I as man and I as man should have dominion over all things, then where, when and how do the things seems to have dominion over I? It's only I can make those corrections. I as man. And if we not make the correction, it will not be corrected, because the adversary will not correct it for you. We will not even direct you to correct yourself. You as man have to do that. And you have to choose to do that. Yeah, man. So the validity of such an inspection, in order for a man stop you and go inspect your vehicle and search you, them have to give notice. And if them you have notice of these things, then null and void, man. You can push them away, man. And this document here alone, you can break this thing wide open for sure. So the moment you don't have no authority, meaning no jurisdiction, meaning no control, stand down. It's that simple. And when you choose to go on, then this is where it's going to carry you. Right to a court of appeal where you're going to become embarrassed. And then it will cost you. So why not cease and desist and avoid the avoidable? Well, if we call out these things and present some little things our simple way, not in a complex way where most people are trying to carry others. I not have no problem with what people choose to do. Free will. But I always try to find a simple way for my common folk to can, apply themselves. Yeah, man. So make we continue.
Inspection. Because HERRERA did not have this notice, as he was in fact not a member of the class subject to these random inspections, the trooper's stop of HERRERA violated the Fourth Amendment. Further, we decline to extend the good faith exception to the exclusionary rule to this case because the Fourth Amendment violation is the result of an officer's mistaken belief that HERRERA fell within the ambit of the Kansas regulatory scheme. Exercising our jurisdiction under 28 U.S.C. Section 1291, we remand this cause to the District Court with directions to vacate HERRERA's conviction and for further proceedings consistent with this opinion. Point 1. Facts. On March 3, 2004, at 8 p.m., a Kansas state trooper encountered HERRERA driving a Ford F-350 pickup truck with New Mexico license plates eastbound on the Kansas Turnpike. The trooper believed HERRERA's truck to be a commercial vehicle under Kansas law because it had your wheels on the back and a utility bed with a heavy lift hydraulic lifter on the back, and also there was a sign on the back, a paint sign for a paint company. HERRERA's truck, however, did not have a Department of Transportation number displayed, as a commercial vehicle would have. The state trooper testified that, under Kansas law, commercial vehicles can be stopped at any time to check for compliance with safety regulations. See Stat Section 74-2108, B, State v. Crum, 270 Carnate 70, 19p.3 D 172, 174-78, Carn 2001, upholding state troopers' random stop made under Stat Section 74-2108. See also United States v. Sislar, 996 F.2 D 1058, 1061-62, 10th Circle 1993, discussing Kansas statutes permitting state troopers to stop certain commercial vehicles. In fact, however, HERRERA's truck was not a commercial vehicle under Kansas law because it weighed 10,000 pounds, 1 pound short of the definition of a commercial vehicle under Kansas law. Point 2.
Here is the technicality. This is what I'm called technicality. So this is how the legal process works. This is why a smart defense attorney will shred a prosecutor if he's not astute. And a smart prosecutor will shred a defense attorney if they're not astute. Pay attention. In fact, however, Joel's Jaguar automobile was not a commercial vehicle under Nantucket laws because it is an unregistered Meaning, you're not registered for go engage in a commerce. You're not getting a third party in an interest in your private property. That's what it means. So it means it's outside of the scope of your commercial arena. It's that simple, people. We not have to be a rocket scientist to figure them things out. We just have to use a legal definition and terms, not just the ordinary thing.
To the state trooper explained his mistake by asserting that he had previously stopped other trucks of the same make and model which had qualified as commercial vehicles because they did have a manufacturer's weight rating over 10,001 pounds.
Yeah, what the state trooper said. Him explained his mistake by asserting that he had previously stopped many other automobiles up there in Nantucket. The man are racially profiled American Indians, now called Negroes, now called African American, now called Black people, sometimes called colored people. The very original people of this location. Because irrespective of what kind of document is out there, those people in Nantucket that doesn't look like us, the original folk, the Negro stock, cannot prove their point of origin is that location. Hence, it makes sense to cease and desist. Yeah, man. This is why I'm tell my people, so declare yourself free. Anywhere you're there, anywhere you are, anywhere you're there, you declare yourself free. Yeah, man. And learn the basic steps. I'm not necessarily talk about the corporate or the commercial or that fictional world. I talk about the earth, living man on the earth. And that's my thing there. Not with all this Roman fanciness, Roman civility. That's all foreign to a man like I. It's all foreign.
After stopping HERRERA, the state trooper arrested him because HERRERA was unable to produce proof of insurance as required under. After stopping HERRERA, the state trooper testified that, under Kansas law, commercial vehicles can be stopped at any time to check for compliance with safety regulations. See Carnstat Section 74-2108, B, State v. Crum, 270 Carnate 70, 19p.3d 172, 174-78, Carn 2001, upholding state troopers' random stop made under Carnstat Section 74-2108. See also United States v. Ceslar, 996 f.2d 1058. 1061-62, 10th Circle 1993, discussing Kansas statutes permitting state troopers to stop certain commercial vehicles. In fact, however, HERRERA's truck was not a commercial vehicle under Kansas law because it weighed 10,000 pounds, 1 pound short of the definition of a commercial vehicle under Kansas law. Point 2. The state trooper explained his mistake by asserting that he had previously stopped other trucks of the same make and model which had qualified as commercial vehicles because they did have a manufacturer's weight rating over 10,001 pounds. According to the trooper, the only way to ascertain whether or not a truck in fact qualified as a commercial vehicle was to stop the vehicle and consult the VIN plate that's on the inside of the driver's door or run the VIN number through the computer. After stopping HERRERA, the state trooper arrested him because HERRERA was unable to produce proof of insurance as required under Kansas law. See Carnstat Section 40-3104. The trooper then conducted an inventory search of the truck, in preparation for towing the truck from the highway following HERRERA's arrest. During that inventory search, the state trooper discovered 23 kilograms of cocaine hidden amidst building materials in the truck's bed. As a result of that discovery, the government charged HERRERA with possessing with the intent to distribute 5 kilograms or more of a substance containing cocaine, in violation of 18 U.S.C. Section 2 and 21 U.S.C. Section 841, A1 and B1, A2. Point 3. HERRERA moved to suppress the evidence seized, as well as the statements HERRERA made during the traffic stop. After conducting an evidentiary hearing, the district court denied HERRERA's motion to suppress. HERRERA then entered a conditional guilty plea to the charged offense, reserving his right to appeal the district court's decision denying his suppression motion. This appeal followed. 2. Discussion. 8. Standard of review. In reviewing a district court's denial of a motion to suppress evidence, we accept the factual findings of the district court and its determination of witness credibility, unless they are clearly erroneous. United States v. Alvarado, 430 F.3d 1305, 1307-2008, 10th Circle 2005, quotation omitted. Further, we consider the evidence in the light most favorable to the district court's ruling, in this case, in the light most favorable to the government. ID at 1308, quotation omitted. The government bears the burden of demonstrating the reasonableness of a warrantless seizure. Says Law 996 F.2d at 1062. We review de novo the ultimate determination of reasonableness under the Fourth Amendment. Alvarado, 430 F.3d at 1308, quotation omitted. Whether the good faith exception to the exclusionary rule applies is a question of law that this court also reviews de novo. United States v. Johnson, 408 F.3d 1313, 1320, 10th Circle 2005, quotation omitted, cert. Denied, 546 U.S. 951, 126 S.CT 458, 163 L.ED2D 348, 2005. B. Whether there was a Fourth Amendment violation. The Fourth Amendment protects the right of the people to be secure against unreasonable searches and seizures. United States v. Bradford, 423 F.3d 1149, 1156, 10th Circle 2005. The basic purpose of this amendment is to safeguard the privacy and security of individuals against arbitrary invasions by governmental officials. Camara v. Municipal Court, 387 U.S. 523, 528, 87 S.CT 1727, 18 L.ED2D 930, 1967. A traffic stop is a seizure within the meaning of the Fourth Amendment, even though the purpose of the stop is limited and the resulting detention quite brief. Bradford, 423 F.3d at 1156, quoting Delaware v. PREJUDICE, 440 U.S. 648, 653, 99 S.CT 1391, 59 L.ED2D 660, 1979. Ordinarily, the government
The Fourth Amendment protect the rights of the people to be secure against unreasonable search and seizure. Now, Fourth Amendment, what is that? Where them get that from? That's the Constitution, people. Yeah, that's the supreme law of the land, people. And Jamaica have such a constitution with such a very same, laws. And when it's a federal, it's straight across the board. Again, as I said, don't watch, they are Jamaican, them they're around this, and them that, no. Straight across the board.
government seeks to justify a traffic stop based on the existence of probable cause, or at least articulable reasonable suspicion, that there has been a criminal violation or that there is evidence of criminal activity in the vehicle.
Now, in the case of my good brother, Joel Jaguasi, State Trooper Kevin M. Bates is very familiar with this good brother, knowing this good brother is a lawful man, upstanding man, and is outside the scope of their jurisdiction. He's aware of all of this. This is why I said these people is like them have a mobster thing, a gangster thing up there where them say the federal laws not apply to them. And them have the state trooper, Kevin M. Bates, out there like, you know, Wild Bill Hickok, where him just do as him please, as long as it's the American original folk, the Negro stock. His kind of people can do all of what them want to do. But the moment him get the list, because they usually function with a list of people where them I work with, and them have the specific areas where them regulate these people. So all them have to do is just look for them, see the color of the vehicle, or him see just the image of whomever him want. Him know them by name, him know them personally. But because it's, you know, it's routine on that Nantucket Island, then you got, you know, see a man in his non-commercial private conveyance. And you say you're a gangster because you're a friend of a tow trucking company will like the man car, so no one thief it. Basically, that's the issue out there, I see. Because if that man was a criminal man, I'm quite sure you'd arrest that man and chop off that man's head long time. But it's like a free man that is, you'd say, not a part of your society or a member of your organization, not supposed to have property, or property where suits that man. It's no different from when you guys went to a place called Rosewood and covet those original Americans there and wipe out the people just to claim them basic assets. People don't know about these stories. People choose to ignore these Rosewood stories. People choose to ignore the trails of tears and say it's the Mongolites, it's those so-called natives. When those people and us are separate and distinct from each other, put it that way. Because when those people get casinos and living lavishly, our people are still here, wondering what's happening. We have enough of it. This is why we say freedom, freedom in, freedom in. And this is for the upright people. Yeah, man, because the moment you're branded a criminal, then all kind of things can happen to you. And the only way you can be branded a criminal is when you engage and entertain in commercial activities. Because all crime are commercial in nature, and that's their laws, not mine. So step by step, people.
Vehicle. See United States v. Tibbetts, 396 F.3 D 1132, 1136-37, 10th Circle 2005. United States v. DeGasso, 369 F.3 D 1139, 1143, 10th Circle 2004. For example, A. An initial traffic stop is valid if based on an observed traffic violation, or If the officer has a reasonable articulable suspicion that a traffic or equipment violation has occurred or is occurring. Tibbets 396F.3d at 11:36 to 37.
Again, remember when a policeman a stop you, him supposed to have probable cause. You know what I mean? Where him a suspect you of committing a crime. This is the next case where them say if your commercial equipment or vehicle is defective out there. But pay attention, people. The moment you're outside of commerce, none of these things apply. None of these things apply. It's all a waste of time where usually the state will have to compensate you for that waste of your time. And again, pay attention to this particular case. When the state trooper inspect this HERRERA car, and HERRERA don't sound like one of our people. HERRERA sound more like one of their people. You understand? When them inspect the car, them find all kind of illicit contraband within that car, within that truck, within that vehicle. Remember now, them charge him fees. And at the end of this case, all like when you have to throw away. Why? If you never have control, authority, or jurisdiction from the start, you cannot get it at the end, irrespective of the shenanigans you guys pull. And this is why I say truth supreme. Because you gotta have good and bad everywhere. You never can exist with just the bad out there. And when the good is there, irrespective of how we try, you gotta find some of the bad that come try each up or mingle up. So this is why me salute my public officials out there who choose to function with clean hands. Once them operate with clean hands, they are honorable. And their dishonor is their unclean hands. And it's easy to demonstrate out there. Easy. It's not complex. The most important thing is to make sure you have record and maintain your record. And that's the most important thing. Because always by their omission or their commission, they shall be judged. By their actions or their inactions, they shall be judged. This is how it is, This is why when I say, boy, I give thanks for success in our cases, because we are do some things where most of us can't even attempt. You know what I mean? But because it's who we are. A lot of us running and feel like we can just, no man. It's like some man where would have see some youth and say them youth, they are KC youth. And show them say a KC youth, them things that the youth, them are some sissy. You understand? And when them try the KC youth show them say, what you say? Even though I go KC, I don't know where I come from. Take this, and take this. Where you feel like? It's no different. It's no different with people like us. Because we come from down a Greenwich farm then. We're not supposed to have function on this level. We not supposed to have bring law to you people. We not supposed to have correct you. It have to be some kind of J. Edgar Hoover kind of guy where the government train, where the government condition, where the government employed. I'll ask this question. If I go sign up like how me have some warrior now, I go sign up with the military. What heap of them we are putting on a thing? Because we say honorable. And when me get all the military training and all of these things and spend 15, 20 years in this thing, and then whoops, I find some like herb and start smoke herb, and them say, I not like you a long time, you know. Now me have that herb thing upon you, I'm going to throw you out for that. Now them throw me out of them system, and them I'm no longer a member of them thing. Tell me this. What the training when me get gone? What me I gonna do with that training there? Where it gone? You know what I mean? It's no different from a police weapon bad. When him have that training they're gone in the badness with him. Not gonna with people. That's why I'm say free will of people that choose for the good or bad. And we have some of our people we choose for try, for learn, so we can know. And then we have another set where them are going to remain in the darkness. The only thing what them do, them put on bright clothing and pretty clothing. Bright clothing, and say, yes, here we are, when them lost in the darkness. But them, they are free will exercise. So we don't mind to share information, credible information. Because them can go do their own research. We don't make up this. I never create this document. Yeah, man, this is an appellate court document, man. And once you're in a jurisdiction from the start, you can't get it later. This is why now I'm not around for say challenge them authority and them control, because them now have none. You can only get it if I submit to that. And I'll never submit to that. Yeah, man. We keep it simple. All of them complexity there.
Quotation omitted. In this case, however, the government does not seek to justify the stop based upon the existence of any individualized suspicion that HERRERA was involved in criminal activity. Point 4. Ordinarily, a search or seizure is unreasonable in the absence of individualized suspicion of wrongdoing. City of Indianapolis v. Edmond, 531 U.S. 32, 37, 121 S.CT 447, 148 L.ED2D 333, 2000. Nonetheless, in this case, the government seeks to justify its initial seizure of HERRERA as a random, warrantless administrative seizure and search 5 permitted by the Kansas statutory scheme regulating motor carriers. CID, recognizing that searches for certain administrative purposes without particularized suspicion of misconduct are allowable provided that those searches are appropriately limited. The Fourth Amendment's prohibition against unreasonable searches still applies to administrative inspections of private commercial property. Donovan v. Dewey, 452 U.S. 594, 598. 101 S.CT 2534, 69 L.E.
Fourth Amendment. Prohibition against unreasonable searches still. Why is this in a open and close bracket? Applies to administrative inspection of private commercial vehicle. You hear that? So you can have a public commercial vehicle and a private commercial vehicle. Me not have no commercial vehicle. And that's the difference. So the moment we engage in a commerce, these foreign people have to go somewhere, go to that business. But our people don't want that. Our people do not want that. Our people say they want commercial financial security by this very commercial construct. So we have to leave our people alone, let them go, do what they want to do, free will. We just point out that at the moment you're in a commerce, this is when the Roman people can employ other people who look like you for talk to you, for regulate you. You understand? For compel you at their bidding and will, for mock you, for brutalize you. And it's okay because you consent to it. I have not. Difference that. So we'll point out them kind of information.
ED2D 262, 1981. But under the Fourth Amendment, an administrative search is very different from a search based upon individualized suspicion. A regulatory search does not require probable cause as defined traditionally by the courts. In general, probable cause, and the less stringent standard of reasonable suspicion, require particularized suspicion, that is, the officer must have some articulable basis to believe that the individual to be searched or seized has committed or is committing a crime. In contrast, a regulatory search is justified if the state's interest in ensuring that a class of regulated persons is obeying the law outweighs the intrusiveness of a program of searches or seizures of those persons.
Hear that? In contrast, a regulatory search is justified if the state's interest, hear that, in ensuring that a class, which class is that, of regulated persons is obeying the law outweighs in the intrusiveness of a program of searches or seizures of those persons. So when I'm calling them persons, and I say what it means? When I say why I'm calling them persons, I try to be impeccable with the words when I use that when I burn on out there. Look at it. Who are these regulated person, class of regulated person? And this is a difference, you know. Then I break it down and I show you a regulatory search is separate and distinct from the common law, which require probable cause. My opinion is that this regulatory search now have nothing to do with common law. This I talk about the contract where them I presume you want them inner. So them are, you know, require you just say actions, or them are compel you to act with their regulatory scheme. This is a legal document, you know, my people. Now just read it ordinarily, you know. Grab out on a law dictionary, you know, and look on all of these words, you know. Because in general, probable cause and the less stringent standard of reasonable suspicion require particularized suspicion, that is, the officer must have some articulable basis to believe that the individual to be searched or seized has committed or is committing a crime. So it's all about your status and who you are, my people. Because when we are not criminal, we don't want a foreign construct criminalized with. We have more than enough criminality and criminals out there for sustain on a business, on a commercial business. Do not interfere with us and our liberty as free people. You know the criminals. You know where the criminals are. You know all of these things out there. You keep a national database and you have agents everywhere. You have double agents everywhere and you have triple agents everywhere. It's just when it is benefiting politically, that's when most of you guys out there will act. And then you run on the news and say, woo, woo, wah, wah, wah. Man, like we not impressed with that domestic mess. We are talking about freedom straight across the earth. Yeah. International, not just local. I love when the people can look on the document, especially some of my people when I read properly. Them get them opportunity I feel look on the words and I hear and I catch up and I take them time. So them information here for my people where I build themselves by their own choice. Yeah, man.
Persons. Says Law 996F.2d at 1061 emphasis in original. The Supreme Court has further distinguished a regulatory search of commercial property from searches of private homes, which generally must be conducted pursuant to a warrant in order to be reasonable, holding that legislative schemes authorizing warrantless administrative searches of commercial property do not necessarily violate the Fourth Amendment. Donovan, 452 U.S. at 598, 101 S.CT 2534, emphasis added. The court has recognized that the expectation of privacy in commercial premises is different from, and indeed less than, a similar expectation in an individual's home. This expectation is particularly attenuated in commercial property employed in closely regulated industries. New York v. Berger, 482 U.S. 691, 700, 107 S.CT 2636, 96 L.ED2D 601, 1987, citation omitted, see.
This is why when we say you guys are considered chattel, you guys are presumed to be slave, to be the property of something or someone else. And a document like this expressed all of those things clearly to a man like I and probably to others. Crystal clearly. Because remember, you know, this expectation is particularly attenuated in commercial property. Again, it's all about the commercial area. And if I am outside of that area, then don't talk to me. Because whatever you have to say can never apply to me. I hope you people get it, you know.
See also Donovan, 452 U.S. at 601-02, 101 S.CT 2534, Marshall v. Barlows, Inc., 436 U.S. 307, 312-13, 98 S.CT 1816, 56 L.ED2D 305, 1978, United States v. Biswell, 406 U.S. 311, 313-17, 92 S.CT 1593, 32 L.ED2D 87, 1972, Seslar, 996 F.2D at 1061. There are, c. 13 industries that have such a history of government oversight that no reasonable expectation of privacy could exist for a proprietor. Berger, 482 U.S. at 700, 107 S.CT 2636, quotations, citation omitted, that is, when an entrepreneur embarks upon such a business, he has voluntarily chosen to subject himself to a full arsenal of governmental regulation. Marshall, 436 U.S. at 313, 98 S.CT 1816. See also Biswell, 406 U.S. at 316, 92 S.CT 1593, noting that W.N.A. Firearms dealer chooses to engage in this pervasively regulated business and to accept a federal license. He does so with the knowledge that his business records, firearms, and ammunition will be subject to effective inspection.
Hear that? Hear that, people? It's a noting that when a firearms dealer chooses to engage in this pervasively regulated business and accept a federal licenses, he does so because it's a contract. Remember, you know, them must say accept and to accept. Seeing them engage in a pervasively regulated business and then them accept a federal contract by way of licenses, then you do so with the knowledge that his business record, firearm, all of these things have to come under inspection. The moment you subject yourself to the contract, to all arrangement by way of a registration and licensing. This is what this document is saying, my people. You understand? And again, it's right here in front of you. If I'm wrong, then tell me say I'm reading it wrong. Tell me say, something else I go on. But if my people not try grasp this level, then it's a repetitious cycle out there. You get me? And the dunce people are choose to be dunce and war amongst themselves. And the smart people are going to try to improve themselves, but still have to encounter the very dunce out there. And the cycle does continue until some more light start to shine in some more places and the change manifests itself.
Inspection. Industries such as these, which includes the sale of liquor and firearms, fall within a carefully defined class of cases. The element that distinguishes these enterprises from ordinary businesses is a long tradition of close government supervision, of which any person who chooses to enter such a business must already be aware. B. Businessmen engaged in such licensed and regulated enterprises accept the burdens as well as the benefits of their trade. The businessman in a regulated industry in effect consents to the restrictions placed upon him.
Hear that again? Because them consider you as a business by how you operate. Because when you operate on the business operate, then you as the businessman in a regulated industry, because it's an industry, the corporation, in effect, you consent to the restrictions placed upon you. You agree to that. You give your consent to that. This is why when I say I am free, then I can express it this way with no problem. It's not being arrogant. It's a truth where the earth not know, what cannot comprehend. You understand? Because if I now say you can't do this or you can't do that, I say I don't give you consent. Me and you not agree. Me and you not have no contract for compel me to do anything at all. So if you're going to do all of these things, then me have a contract in place to say you're going to have to pay for all of these things where you have done. That's why we have a fee schedule in place. And these things are going to be brought to bear. But as we go along, we have to walk our people through it and show them that this is what it is. Because the Fourth Amendment was supposed to give you rights. It's not giving the rights. It secures the rights where you have inherently. And this is why these people are trying to distance themselves from what is known as the supreme law of the land. On this island, our so-called constitution, specifically the amendment of the Charter of Fundamental Rights and Freedoms. How my people now read these documents, look over these documents, and always talk about these documents. I man walk with that document, just like how I walk with the Universal Declaration on Human Rights, not gay rights, not civil rights, not religious rights, human rights. So if you consider yourself man of the earth and you have you, then them rights you have for you. Define H-U-E, where you get. And we always know we are a man, but we just remove that prefix. And we say we are man. We don't have to say we are human. We are man. The Most High never create a human. The Most High create man in his image. So we as man have inherent right, unalienable right, divine rights we have. It not come from a corporate construct or a man. So when all that state trooper like Kevin Bates, because him a work for a mobster organization out there on Nantucket Island, say him can disregard the federal laws that is in place and do what him want. And him can confiscate or thief free people's property. Free people where is non-members to their mobster society where them have up there. Where I think them have a plan to turn that whole island into a tourist resort. Where them no want to see no original people there. And the original people there, that's a play right there in them hand. They keep running. So the people them raise the price. The people them keep running away from the island. No different from here in Jamaica. I'm there in a Portmore. My big ghetto of a Portmore. And if you go to the shop and buy some item, it costs way much more than the people them were shopping at Ochi. And I have first-hand knowledge of that. When I saw it, I couldn't believe it. I saw Ochi and them place a tourist resort. And them I sell the basic thing down there way more, at least $50 and $60 cheaper than what we are dealing with in our city. So I say, what could I go on? And you would think them Ochi they are more the money people and place because foreign people are come through those places. So things should have been much higher. When you pay all $100 for probably a drinks here in our city, if you pay $200-$300 feet now them tourist area there. However, you pay like 75 cent feet over there. Way much less. So I don't know what go on. These things are things where our people need to look into. Well, let's continue. Let's continue.
Marshall, 436 US at 313, 98s.ct 1816, quotation, citation omitted. Because the owner or operator of commercial premises in a closely regulated industry has a reduced expectation of privacy, the warrant and probable cause requirements, which fulfill the traditional Fourth Amendment standard of reasonableness for a governmental search, have lessened application in this context. Rather, we conclude that, as in other situations of special needs, where the privacy interests of the owner are weakened and the government interests in regulating particular businesses are concomitantly heightened, a warrantless inspection of commercial premises may well be reasonable within the meaning of the Fourth Amendment.
Only because it's a commercial premises. You cannot enter an individual home without warrant. There's no such thing. Because the individual have that inherent right to protect his home from any entity, foreign or domestic, any entity. A man's home is his castle. However, if your house is a commercial area and part of an industry, commercial industry, then it may be subject to fair game. Yeah, man. Especially when there is no free inhabitant inexistent there.
This warrantless inspection, however, even in the context of a pervasively regulated business, will be deemed to be reasonable only so long as three criteria are met. First, there must be a substantial government interest that informs the regulatory scheme pursuant to which the inspection is made. Second, the warrantless inspections must be necessary to further the regulatory scheme. Finally, the statute's inspection program, in terms of the certainty and regularity of its application, must provide a constitutionally adequate substitute for a warrant. In other words, the regulatory statute must perform the two basic functions of a warrant. It must advise the owner of the commercial premises that the search is being made pursuant to the law and has a properly defined scope, and it must limit the discretion of the inspecting officers. Point 6 to perform this first function. The statute must be sufficiently comprehensive and defined that the owner of commercial property cannot help but be aware that his property will be subject to periodic inspections undertaken for specific purposes. In addition, in defining how a statute limits the discretion of the inspectors, we have observed that it must be carefully limited in time, place, and scope. Berger, 482 US at 702-03, 107s.ct 2636, citations, quotations, alterations omitted. Footnote, emphasis added. The random detention and inspection of a vehicle used in a closely regulated industry must meet essentially the same requirements as a warrantless regulatory search of business premises.
The random detention and inspection of a vehicle used in a closely regulated industry. What is that? Where is that? Have you guys getting full disclosure or even closure or even notice that you're operating in a regulated industry with regulatory statutes? Were you guys properly informed of your capacity as such? I don't think so.
Premises. V1 Oil Company V means 94F.3D 1420, 1425, 10th Circle 1996. In this case, HERRERA does not challenge the constitutional validity of the Kansas statutory scheme regulating motor carriers, nor does he challenge the trooper's authority under that scheme to stop vehicles subject to that regulation for random inspection. For purposes of this appeal, therefore, we will assume that motor carriers are engaged in a pervasively regulated industry and that the Kansas regulatory scheme applicable to those motor carriers properly permits state troopers to stop commercial vehicles randomly for inspection. See United States v. Birch, 153 F.3D 1140, 1142, 10th Circle 1998, Assam, Inc., without deciding that the regulations of the trucking industry in Kansas performed the two basic functions of a warrant as Berger requires, says law, 996 F.2D at 1063 N3, Assam, Inc., without holding that Kansas closely regulates the motor carrier industry and that the Kansas regulatory scheme satisfies the Berger three-part test. The problem this case presents is that HERRERA's truck did not fall within Kansas's definition of a commercial vehicle subject to these random regulatory seizures and searches. HERRERA was not engaging in a closely regulated industry and, thus, would not have had any reason to know that his truck could be subject to a random inspection. 7C says law, 996 F.2D at 1062. Noting that the Supreme Court cases addressing regulatory searches all involve defendants who are obviously engaged in the regulated industry, emphasis added. It is clear, then, that the state troopers stopping HERRERA cannot be justified under the Kansas regulatory scheme. We reached a similar conclusion in Seslaw, 996 F.2D 1058. There, this court held that the closely regulated industry line of cases does not justify the warrantless search of UN-regulated persons. ID at 1063, emphasis in original. That case controls here. In Seslaw, a Kansas state trooper stopped a rental truck to determine if the truck was subject to Kansas regulations governing motor carriers. 8. See ID at 1059. In that case, this court rejected the government's assertion that a Kansas state trooper can randomly stop any truck on the highway, whether operated by a motor carrier or not, to first determine whether the truck is covered by that scheme. ID at 1062, see also ID at 1063. B. It calls the justification for permitting warrantless, regulatory, searches is that persons doing business in closely regulated industries have a significantly reduced expectation of privacy. ID at 1061. This court held that such a stop was not justified by the regulatory scheme if the truck did not fall within the parameters of that regulation. See ID at 1062-63. See also State v. Campbell, 19 Carnap.2D 778. 875p.2D 1010, 1013-14, Khan CT at .1994, holding random stop of rental truck that was transporting private property and thus was not subject to Kansas regulations governing motor carriers, violated 4th Amendment, Dominguez v. State, 290 Arc 428, 720 SW. 2D 703, 707-08, ARC 1986, holding that a statute that arguably authorized random stops of motor carriers could not be read to authorize random stops of any motor vehicle merely to determine whether the detainees belong to the regulated class, cited with approval in CESLA 996 F.2d at 1063. Applying CESLA to this case, then, we conclude that because HERRERA's truck was not a commercial vehicle subject to the Kansas regulatory scheme, that scheme cannot justify the state troopers stopping HERRERA. Because that is the only justification the government offers for this stop, that warrantless stop violated the Fourth Amendment. The government further argues, however, that there can be no constitutional violation here because, even though HERRERA's truck did not in fact qualify as a commercial vehicle under Kansas law, the state trooper had an objectively reasonable, yet mistaken, belief that it did. Indeed, the trooper was mistaken by only 1 pound in believing that HERRERA's truck was a commercial vehicle subject to the Kansas regulatory scheme.
Well, in this case, State Trooper, Nantucket State Trooper Kevin Bates cannot make a claim of mistaking by only 1 pound here when Joel Jaguar's automobile clearly demonstrate it have a private plates on it, meaning outside of commerce. So that in and of itself should be obvious to a trained veteran such as Kevin M. Bates out there on Nantucket Island. And this is why it's safe to say these guys are not just operating their own Ponzi scheme and criminal organizational enterprise out there, because remember, it's talking about regulatory scheme. And what is a scheme? This is why I like the older documents. And I love this new thing where they change up everything, and then we have some new age people that try mess around with these new mess. Document like this has set precedent, and it demonstrates that from you have no authority at the start, you can't get no authority nowhere at the end, period. This is what we are trying to demonstrate. And remember, with this particular case, this HERRERA was involved in some criminality because he have some kind of illicit, things in that very vehicle, and it still have to get thrown away. Now, our good brother was a lawful man traveling in Nantucket. No criminality, no criminal record. But this state trooper, Kevin Bates, and his cronies chose to harass this man, take a set on this man. Not just him, but this man here is a part of what we call the AhuuakHindianNation, our society. So we have to speak up on behalf of this man. Other people who choose to subject themselves to the torture and the humiliation and the slavery, that's their free will choice. We can't get involved. Yeah, man, but you can't break the law in order to maintain some racist agenda out there on Nantucket Island. And I know it's not everybody out there still like Kevin M. Bates, because my good brethren Joel Jaguasi let me know said the brethren where him work with on that trading post is a foreign man, and is a good foreign man. This is why I cannot be racist. But I'll call you out, Gerard Taylor, when you are. Because Gerard Taylor and Kevin M. Bates are the same kind of people. Truly. Yeah, man. But I like Gerard Taylor because he now hide his true nature, even though he is a Japanese. You know what I mean? Because I'm born in Japan. So corporately you're Japanese. But in the hide the facts and love theme kind. But you have some mobster in Nantucket. I'm not sure. We have to start pay close attention up there. These guys say them not deal with federal law, them above that. That's what them guys here say out there. And them not necessarily look for criminal, them just want to hold on upon the Negro people and what them can say. It's like a habit, it seems, for this state trooper. I don't know. I'm only presuming, just like how them are presumed so them have control and authority over free people. So I'm just presuming so this guy is a staunch racist, where all them do is racially profile Negro people, so-called. The moment you see me in a trouble, I'm only presuming. I can be wrong. I wouldn't mind you guys proving me wrong. However, let's continue.
Scheme. The government's argument might be persuasive if it had sought to justify this stop based upon individualized suspicion. That is, if the government had argued that the trooper had probable cause or at least reasonable suspicion to believe that HERRERA was involved in criminal activity. This court has consistently held that an officer's mistake of fact may support probable cause or reasonable suspicion necessary to justify a traffic stop, provided the officer's mistake of fact was objectively reasonable. 9. Tibbetts, 396F.3d at 1138. See also DeGasso, 369F.3d at 1144. United States v. Vircher, 358F.3d 1257, 1261, 10th Circle 2004. Noting reasonable suspicion may be supported by an objectively reasonable good faith belief even if premised on factual error. Compare to Illinois v. Rodriguez, 497 U.S. 177, 179, 186, 110 S.CT 2793, 111 L.ED2D 148, 1990, upholding validity of search of apartment premised on officer's factual mistake in believing that third-party consenting to search possessed sufficient common authority over premises such that she could validly consent.
You hear that? I don't even want to repeat that.
Consent. In this case, however, the government does not seek to justify its stop of HERRERA based upon the existence of probable cause or reasonable suspicion that he was involved in criminal activity. Rather, the government justifies the stop only as a random regulatory inspection. Therefore, our case is addressing the existence of reasonable suspicion or probable cause based upon factual mistakes are inapposite. That is because, as we have noted, a regulatory inspection is not premised on an officer's on-the-spot perception that he has an individualized suspicion that the specific individual to be seized and searched is involved in criminal activity. An administrative search is instead premised on the individual subject to the warrantless seizure and search knowingly and voluntarily engaging in a pervasively regulated business, and on the existence of a statutory scheme that puts the individual on notice that he will be subject to warrantless administrative seizures and searches.
An administrative search is instead premised on the individual subject premised on the individual subject to the warrantless seizure and search, knowingly and voluntarily engaging in a pervasive regulated business, and on the existence of a statutory scheme. What is a statutory scheme? That puts that individual on notice. Did you get that notice from the states? That he will be subject to warrantless administrative seizure and searches. These are the things our people need to pay attention to. And I'm talking us who are lawful in our activities and capacity. This is why I know them not want me in them court. They don't want me in Jamaica court system. I'm like that. I like when them try learn and subtly correct themselves. But don't try criminalize me and bring me in on a court system. This is why I'm embarrassed enough every time when I did. Because I've always been demonstrating that we have to have a private setting for a man like I. We have to open to the public where everybody are here. And that happened the very last time I went to the very last court, and I'm quite sure I won't be going into no more. I'm sure our system have no interest in even talking to me in them court. Them no mind not talk to me when them see me on the street somewhere. But I'm sure absolutely nobody no want me in them court, especially when them know them not have no jurisdiction or authority. You get me? And my officials know me, say, watch out. Him not no criminal. Anytime I'm getting a criminality, we all are going to know about it. Because I'm going to lift the whole island. You hear me telling you? We have to choose good people. That is a, choice. And we not go make nobody tell we say, boy, it's not popular. You understand? If we always are focused, and all of us just focus on the negative of everything, then we state a condition are going to be such. If I live in a community, it's just that a community. We are going to have an area where we know that this is where we are, while the extending communities out there. And when the craziness go on out there, where it even go on anywhere and affect everybody, then a man like me and my free will choice for say, should I make this thing depress me? Should I take this thing inside of me and, become like the rest out there? Or should I just focus on the task at hand and allow the dead to bury the dead? I have my time when I have interest in the news and what's going on, but lately, it become too much, really. Because me know nothing new. When we are little boy, we say the same atrocity what we are seeing now as big man. I don't know what people are talking about out there. The very same atrocities. As little boy, we see it and hear it. And the same thing we are experiencing as big man. It's probably more pervasive because the animal them turn loose. So I have to forgive a man like me when I not share the same views as Uno out there. And with all of the craziness, I find it strange how I keep my gate and my door open and I just do the simple things them same way. I find it strange. I don't know. When me hear about what go on in a Portmore and down to the other day, I have to say to a man, I say, yeah, all the place are quiet. Because when I say I like certain time, the place really quiet. And I like when I know say all kind of problem are going out there. But me know say it gonna get worse too before it start getting better. Because so the purge go. I saw them thing I go, man. And when man I cry over that one because that one, me always I say then what the truth? What's the root of all of it? We can only say condolence and we can only sympathize, but at the end of the day, the Most High is in control, man. Because the bad are going to remain bad, and the good are going to always make the effort to remain good. Let's continue.
Searches. See generally Birch, 153 F.3d at 1143, distinguishing generally between traffic stops premised on reasonable suspicion and those premised on an administrative search. The government's argument that there was no Fourth Amendment violation in this case because the state trooper had an objectively reasonable, but mistaken, belief that HERRERA was subject to a random administrative inspection focuses on the wrong participant in the seizure at issue here. The validity of an administrative seizure and search does not turn on whether or not the trooper had an objectively reasonable belief that HERRERA's truck qualified as a commercial vehicle subject to random inspections. Rather, it turns on HERRERA's decision to engage in a pervasively regulated business, knowing that by doing so he would be subject to random warrantless inspections. The validity of an administrative inspection is premised on the fact that the owner of the property subject to the search cannot help but be aware that his property will be subject to periodic, administrative, inspections undertaken for specific purposes. Berger, 482 U.S. at 703, 107 S.CT 2636, quotation omitted. It is only under such circumstances that the individual citizen has a reduced expectation of privacy in his or her commercial property that justifies a warrantless regulatory search and seizure under the Fourth Amendment. See ID at 700, 703. But in this case, HERRERA had never chosen to engage in a pervasively regulated business and so, of course, had no notice or understanding that he could be subject to random warrantless seizures and inspections. He was, then, completely unaware, and reasonably so, that a law enforcement officer might seize and search his vehicle randomly pursuant to a regulatory scheme that did not apply to him. 10 C. says law, 996 F.2d at 1062-63. See also Dominguez, 720 S.W.2d at 707. The state trooper in this case testified that the only way to determine whether or not HERRERA's truck weighed over 10,000 pounds and was thus a commercial vehicle subject to random seizures and searches under Kansas law was to stop the truck and check the VIN plate. 11 But permitting a state trooper to stop any vehicle simply to ascertain whether or not the vehicle was subject to a random regulatory search would allow the officer the unbridled discretion that the Supreme Court sought to preclude in Berger. C. Campbell, 875 P.2d at 1013-14. See also Dominguez, 720 S.W.2d at 707. This says law forbids. C. 996 F.2d at 1062-63. It would be a circumvention of the Fourth Amendment if the business exception to the probable cause or warrant requirement could be used wholly out of the context of its justification. ID at 1063, quoting Dominguez, 720 S.W.2d at 707, alteration omitted. In summary, determine the initial validity of a traffic stop. We ask whether the stop was objectively justified. DeGasso, 369 F.3d at 1143, quotation omitted. Because the government sought to justify its stopping HERRERA in this case based only upon a regulatory scheme permitting random administrative inspections of commercial vehicles, the authority for that stop must come from that regulatory scheme. And because HERRERA's truck did not fall within the class of vehicles subject to that regulatory scheme's random inspections, the state trooper in this case had no authority to stop HERRERA. The trooper's seizure of HERRERA, therefore, violated the Fourth Amendment.
There you go. State Trooper Kevin M. Bates. Hey, I might just, bit of hound there on your thing where you know, say, boy, every time you look up here, we are call your name. We are call your name and we are do it publicly. Yeah, because we are presumed until you rebut our presumption that you're a staunch racist or racially profiled original American people of this hemisphere. You don't care. And this is only a presumption. So it's up to you to rebut this presumption of ours, just like how we are rebut your presumption that you have any authority, because it is stated right here by learned folk, people will spend millions of dollars on them education to talk about legal opinions, and them said to determine the initial validity of a traffic stop, we, the court, are going to ask whether the stop was objectively justified, because the government sought to justify stopping this man in this case based only upon a regulatory scheme which permit random administrative inspection of commercial vehicles. So you have no authority over non-commercial vehicles or non-commercial automobile or non-commercial anything at all. Once it's outside of commerce, it not apply. You know, an authority. These are the things we have been saying. These are the things we have been saying. And if you're saying, hey, you are present the contract where me and you create and sign, well, we have meeting of the present those contracts. And them thing I may talk about in the people. Not the bag of fanciness and the hoopla like me know on a legalese and me know on a legal process. Because that's a sham. What we are dealing with is law. Present the law. Present the authority. Here it's saying clearly, Kevin M. Bates, State Trooper, Nantucket, to determine the initial validity of a traffic stop. We asked whether the stop was objectively justified, because you, Kevin M. Bates, working for the government, sought to justify the stop. In this case, based only on a regulatory scheme permitting random administrative inspection of commercial vehicles. Kevin M. Bates, State Trooper Kevin M. Bates, our good brother Joel Jaguasi, private automobile, demonstrate that it is outside of commerce. Yeah, man. When you say the AhuuakHindianNation decal, it represent non-commercial activities. That's what it deal with. We are talking about a private area right there. We are talking about a private trust organization right there. When you say AhuuakHindianNation, that's what the item I deal with. So State Trooper Kevin M. Bates, seizure of Joel Jaguar's private automobile, violate the Fourth Amendment. It violates the constitutional laws. It violates the Bill of Rights. But these guys say them are old gangster up there, you know? Them are Quaker and them things. Them say, boy, federal laws not apply to them up there, even though them get federal money. Now that is interesting.
Amendment. See whether the good faith exception to the application of the exclusionary rule should apply under the circumstances of this case. Having concluded that there was a Fourth Amendment violation in this case because HERRERA's truck was not a commercial vehicle subject to the random inspections permitted under the Kansas scheme regulating motor carriers, we must decide what to do about that violation. That question leads us to United States v. Leon, 468 U.S. 897, 104 S.CT 3405, 82 L.ED2D 677, 1984. In Leon, the Supreme Court accepted that there had been a Fourth Amendment violation when police officers seized evidence pursuant to a search warrant that a court later determined was not supported by probable cause. CID at 902-03, 905, 104S.CT3405. The Supreme Court, therefore, had to decide the appropriate remedy for the Fourth Amendment violation occurring in that case. CID at 906, 104S.CT. 3405, noting that w. whether the exclusionary sanction is appropriately imposed as a remedy in a particular case, our decisions make clear, is an issue separate from the question whether the Fourth Amendment rights of a party seeking to invoke the rule were violated by police conduct. Quotation omitted. See also United States v. Nielsen, 415 F.3d 1195, 1202, 10th Circle 2005, petition for cert.
Interesting. Whether the exclusionary sanction is appropriately imposed as a remedy in a particular case. Who miss it? Who miss it? Now, this is where we are to be, where we're outside your regulatory scheme of things. And you have to know that there's an exclusionary sanction imposed as remedy. So when you see it, you know, say, boy, we're outside their scope. No different from them American nationals say, hey, we on you do not detain, do not here. So for the people when they reach that level and find themselves in a trouble, this is how we have to approach them. And the moment you upgrade your status, then none of these things are necessary. None of these things are necessary. Boy, my people are hoping I get it, you know. Because we are function, you know, on about 12 cylinder right now.
Cert. Filed 74 USLW 3532, US March 10, 2006, number 05-1152. Ordinarily, courts will remedy a Fourth Amendment violation by invoking the exclusionary rule to exclude the government's introduction of the unlawfully seized evidence as direct evidence against the defendant in a criminal prosecution. See Illinois v. Kroll, 480 U.S. 340, 347, 107S.CT 1160, 94L.ED2D 364, 1987. See also James v. Illinois, 493 U.S. 307, 311, 110S.CT 648, 107L.ED2D 676, 1990. Noting exclusionary rule is the principal mode of discouraging lawless police conduct.
Absolutely beautiful. My people are hoping I get it, you know.
Conduct. Without it, the constitutional guarantee against unreasonable searches and seizures would be a mere form of words. Alteration, quotation omitted, United States v. Hill, 60 F.3d 672, 677-78, 10th Circle 1995, discussing exclusionary rule. But the exclusionary rule is only a judicially created remedy designed to safeguard Fourth Amendment rights generally through its deterrent effect, and is not a personal constitutional right of the party aggrieved. Leon, 468 U.S. at 906, 104S.CT 3405, quotation omitted. Further, the exclusionary rule is harsh, requiring the exclusion of potentially reliable evidence of wrongdoing. Nielsen, 415 F.3d at 1202. Therefore, the Supreme Court in Leon concluded that the exclusionary rule should be invoked only when doing so furthers the purpose of that rule, which is designed to deter police misconduct. Leon, 468 U.S. at 916, 104 S.CT 3405, emphasis added. The Leon court concluded that, even if an officer in a given case obtained evidence in violation of the Fourth Amendment, it made no sense to exclude that evidence if the officer was nevertheless acting in an objectively reasonable manner when he seized the evidence. See ID at 918 to 20, 104 S.CT 3405. We will ordinarily not deter, nor do we want to deter, objectively reasonable police conduct. See ID. In Leon, then, the Supreme Court adopted a good faith exception to the application of the exclusionary rule and specifically applied that exception where an officer acting with objective good faith has obtained a search warrant from a judge or magistrate and acted within its scope, even though the search warrant was later deemed to be invalid.
Now, that is exercising good faith conduct. In Leon, then, the Supreme Court adopted a good faith exception to the application of the exclusionary rules and specifically applied the exception where an officer acting with objective good faith has obtained a search warrant from a judge or magistrate and act within its scope. That is acting under good faith. Now, when a man run in and do his own thing, there is no good faith there. There is malicious intent. Yeah, man. Malicious intent. Yeah, man.
Invalid. ID at 920. In this case, the government asks that we extend Leon's good faith exception and decline to exclude the evidence obtained during the state troopers' unconstitutional but arguably good faith traffic stop of HERRERA. We decline to do so in this case for two reasons. First, Leon's good faith exception applies only narrowly, and ordinarily only where an officer relies, in an objectively reasonable manner, on a mistake made by someone other than the officer. But in this case, it was the state trooper's own factual mistake that led to the Fourth Amendment violation that occurred in this case. Second, the Fourth Amendment violation in this case occurred in the context of the state troopers conducting a random warrantless administrative search of someone who was not in fact subject to such a search. Unlike a stop based upon probable cause or reasonable suspicion, the validity of a warrantless administrative search is premised on the party who is subject to the search being aware that he is subject to such a search. In the context of an administrative search, limiting an officer's ability to stop only those individuals who are actually subject to such a search will satisfy both Leon's purpose of deterring unconstitutional police errors as well as the Fourth Amendment principles underlying the validity of a warrantless administrative search that those being searched be objectively aware that they are subject to such a search. 1. Leon's good faith exception is ordinarily limited to situations when the police officer reasonably relied upon the judgment of a neutral third party. Courts applying the good faith exception recognized in Leon have done so only in very narrow circumstances. The Supreme Court, although expanding the good faith exception's application a bit beyond the facts of Leon, has still limited that exception to circumstances where someone other than a police officer has made the mistaken determination that resulted in the Fourth Amendment violation. In Leon, for example, it was the magistrate who mistakenly issued the search warrant without probable cause. See 468 U.S. at 905, 913 to 14, 920 to 21, 104 S.CT 3405. Such circumstances represent the most common application of Leon's good faith exception. Thus, this court has applied the good faith exception primarily when, as in Leon, the officers involved in a seizure or search have acted in an objectively reasonable manner by relying on a warrant issued by a neutral and detached magistrate. 12. See example United States v. Soderstrand, 412 F.3 D 1146, 1152, 10th Circle 2005, cert denied.
Thus, this court has applied the good faith exception primarily when, as in Leon, the officers involved in a seizure or search have acted in an objectively reasonable manner by relying on a warrant issued by a neutral and detached magistrate. That's the third party right there, representing what is known as the court. So when any officer without a warrant I go confiscate your private property, then no, he's acting unlawfully. He's acting outside the scope of his authority. I would ask a question, are you not a man such as I? Present the authority or the contract that give you control or jurisdiction to my property. Outside of that, it's called theft.
Denied. 547 US 1004, 126 S.CT 1478, 164 L.ED2D 249, 2006, United States v. Riccardi, 405 F.3 D 852, 863 to 64, 10th Circle, cert. Denied. 546 US 919. 126 S.CT 299, 163 L.ED2D 260, 2005, United States v. Laura Solano, 330 F.3 D 1288, 1294 to 95, 10th Circle 2003, dicta. The Supreme Court did extend Leon's good faith exception, applying it where officers conducting a search relied in good faith, not on a warrant, but on a statute's regulatory scheme that permitted warrantless administrative searches.
Where officers conducting a search relied on good faith, not on a warrant, but on a statute's regulatory scheme. A statute's regulatory scheme that permitted warrantless administrative searches. So you have two kind of approach to this thing. Isn't this obvious, my people? You have a statutory regulatory scheme. When I have nothing to do with due process. And then you have a due process, which is common law. I love the document here because the narrative is, it's just so expressive.
Searches, when that statutory regulatory scheme was later declared unconstitutional. See Kroll, 400.
Hear it, people. Why is it declared unconstitutional? And if it's declared unconstitutional, why is it an issue? Because the Constitution is the law. And the Constitution secures us as people, man and woman. You get me? It secures the rights that we have inherently. And it's always a contract. So you just have to know your position, people. It's just so amusing to me,
480 US at 343, 346, 353, 356 to 57, 107s.ct 1160. But in Kroll, it was the legislature's mistake in enacting an unconstitutional statute, rather than any error on the officer's part, that led to the Fourth Amendment violation. See ID at 349 to 53, 107s.ct 1160. See also United States v. Van Ness, 342 F.3d 1093, 1094 to 96, 1097 to 1100, 10th Circle 2003, applying Kroll and the good faith exception, without deciding whether city noise ordinance was constitutional, where officers reasonably relied on the ordinance to stop defendant. In addition, the Supreme Court indicated that the Leon exception to the exclusionary rule would apply where an officer had acted in reliance on a police record indicating the existence of an outstanding arrest warrant, if that error was made by a court clerk's employee rather than a police officer. See Arizona v. Evans, 514 U.S. 1, 3-4, 14-16, 115s.ct 1185, 131l.ed2d34, 1995. In Evans, the Supreme Court remanded for the state court to determine who was responsible for the error, a court clerk's employee or the police. See ID at 15-16, 115s.ct 1185. If court employees were responsible for the erroneous computer record, the exclusion of evidence at trial would not sufficiently deter future errors so as to warrant such a severe sanction. If it were indeed a court clerk who was responsible for the erroneous entry on the police computer, application of the exclusionary rule could not be expected to alter the behavior of the arresting officer. Excluding the evidence can in no way affect the officer's future conduct unless it is to make him less willing to do his duty. Application of the Leon framework supports a categorical exception to the exclusionary rule for clerical errors of court employees. ID at 14, 15-16, 115s.ct 1185, quotation, alteration omitted. Thus, application of Leon's good faith exception to the exclusionary rule turns to a great extent on whose mistake produces the Fourth Amendment violation. And because the purpose underlying this good faith exception is to deter police conduct, logically Leon's exception most frequently applies where the mistake was made by someone other than the officer executing the search that violated the Fourth Amendment. The Supreme Court has never extended Leon's good faith exception beyond circumstances where an officer has relied in good faith on a mistake made by someone other than the police, that is, on someone outside the police officer's often competitive enterprise of ferreting out crime. Leon, 468 U.S. at 914, 104s.ct 3405, quotation omitted. See also 1 Lefebvre, Search and Seizure Section 1.3, F, noting that Leon does not allow law enforcement authorities to rely on an error of their own making, quotation omitted, 2 Lefebvre, Search and Seizure Section 3. 5d, noting the Evans rationale would seem inapplicable whenever the mistake was instead attributable to the law enforcement agency, compared to Groh, 540 U.S. at 563-64, 124s.ct 1284, refusing to apply the good faith exception, and refusing to conclude that the officer was entitled to qualified immunity in a civil action for damages, where the officer himself prepared the invalid warrant and so he may not argue that he reasonably relied on the magistrate's assurance that the warrant contained an adequate description of the things to be seized and was therefore valid. 13. Nor has this court ever extended Leon to a case where it was the officer's mistake, rather than that of a neutral third party, that resulted in a Fourth Amendment violation. 14. In United States v. Scales, 903 F.2d 765, 10th Circle 1990, this court refused to apply Leon's good faith exception where officers, acting without a warrant, unlawfully seized a suitcase and held it for 24 hours before obtaining a warrant. See ID at 767 to 68. In doing so, this court specifically declined d. to extend the holding of Leon to cases in which the good faith of the officer cannot be presumptively established by the existence of a search warrant valid on its face. ID at 768. And in United States v. Owens, 782 F.2d 146, 10th Circle 1986, this court again declined to apply the good faith exception where officers had effected an unlawful warrantless entry into a hotel room. ID at 150 to 52. In reaching that decision, this court specifically noted that the officers had watched that hotel room for 5.5 hours without making any attempt to obtain a search warrant. See ID at 152. This authority, from both the Supreme Court and this circuit, indicates that Leon's good faith exception to the exclusionary rule generally applies only narrowly outside the context of a warrant. It has not been applied when the mistake resulting in the Fourth Amendment violation is that of the officer conducting the seizure and search, rather than a neutral third party not engaged in the competitive endeavor of ferreting out crime. Leon, 468 U.S. at 914, 104 S.CT 3405, quotation omitted. In light of this very narrow application of Leon's good faith exception, we are disinclined to extend that exception to the facts of this case, where a state trooper conducted a random, warrantless seizure to effect an administrative search based upon the officer's own mistaken belief that HERRERA's truck was subject to such a random inspection. We acknowledge that this court has, on one occasion, suggested extending the good faith exception in the context of a warrantless administrative search, where the officers conducting the search interpreted their authority to do so under the relevant statutes in an objectively reasonable manner. See Johnson, 408 F.3d at 1322 to 23. But Johnson is different from this case. In Johnson, officers conducted a warrantless administrative search of a salvage yard pursuant to an Oklahoma statutory regulatory scheme. See ID at 1316 and N2. The officers conducting the inspection searched not only the business premises, but they also searched a locked toolbox found at the salvage yard and belonging to a salvage yard employee. See ID at 1317 to 19. This court first determined that the relevant Oklahoma statutes authorized the officer's search of both the salvage yard and the locked toolbox. 15. See ID at 1320 to 22. In dicta, this court then indicated that even if these Oklahoma statutes did not permit the search, the good faith exception to the exclusionary rule would apply in light of the officer's good faith reliance on those statutes. See ID at 1322 to 23. More specifically, as to the search of the locked toolbox, this court indicated that, even if the Oklahoma statutes did not permit that aspect of the administrative search, Leon's good faith exception would apply because the officers reasonably interpreted those statutes to permit the toolbox search. See ID at 1323. The officers would have no reason to believe they could not demand to inspect inside a locked container which they reasonably believed to be subject to the search, particularly when they had developed additional, reasonable, suspicion during the conclusion. There are, admittedly, several Fourth Amendment principles that are in tension in this case. First, Leon recognizes that the exclusionary rule is a prophylactic doctrine designed to modify police conduct that is not objectively reasonable. That suggests that so long as officers are acting in an objectively reasonable manner, a court should not exclude evidence obtained contrary to the Fourth Amendment because to do so would not have the desired deterrent effect. But here, previous Tenth Circuit authority, says law, precludes a search for the purpose of determining whether a vehicle is in fact covered by Kansas's regulatory statutes authorizing an administrative search. Excluding the evidence obtained as a result of this unauthorized administrative search will have the beneficial effect of requiring police officers to determine in advance whether a vehicle is in fact a rated commercial vehicle before executing an administrative stop. Further, the validity
excluding the evidence obtained as a result of this unauthorized administrative search will have the beneficial effect of requiring police officers to determine in advance whether a vehicle is in fact a rated commercial vehicle before executing an administrative stop. So you have a lawful stop, common law, and you have an unlawful stop, administrative stop, the legal part of it. Interesting.
validity of such a warrantless administrative search under the Fourth Amendment is premised on clear notice to those subject to such a search. Applying Leon in the context of an unconstitutional regulatory search based upon just the officer's reasonable factual mistake would go beyond the underlying justification for deeming such a regulatory search valid under the Fourth Amendment that the person engaging in a pervasively regulated business is aware of and accepts the burdens of a random warrantless administrative search or seizure. Under these circumstances, we determine that we are most faithful to the Fourth Amendment and to the doctrine of the regulatory search exception to the warrant requirement if we conclude that this search and seizure are constitutionally infirm and exclude the fruits of the search and seizure. 3. Conclusion. For the foregoing reasons, we conclude that stopping HERRERA to effect a random inspection of commercial vehicles violated HERRERA's Fourth Amendment rights because HERRERA's vehicle was not a commercial vehicle subject to random inspection under Kansas law. Further, we decline to apply Leon's good faith exception to the application of the exclusionary rule under the facts of this case. Therefore, the evidence discovered during the unconstitutional seizure must be suppressed. We thus remand this case to the District Court with directions to vacate HERRERA's conviction and for such further proceedings as are consistent with this opinion. Footnotes. 1. After examining the briefs and appellate record, this panel has determined unanimously to grant the parties' request for a decision on the briefs without oral argument. See Federation.app. P. 34, F. and 10th Circle are 34.1, G. 2. Kansas statutes regulate, among others, public and private motor carriers of property. Stat Section 66 to 1111. See also ID Section 66 to 1108, further defining these terms. The government asserts that the state trooper in this case specifically believed that HERRERA was a private motor carrier of property. Kansas law describes a private motor carrier of property as a person who provides transportation of property by commercial vehicle and is not a for-hire motor carrier. ID Section 66-1, 108, emphasis added. And Kansas administrative regulations define a commercial motor vehicle to include a vehicle that has a gross vehicle weight rating or gross combination weight rating of 10,001 or more pounds. Khan Admin. Reg 82-4-1, C1. That rating is established by the manufacturer. See Stat Section 66-1, 108, C. The rating can be ascertained using the vehicle's identification number, VIN. In other words, the determination of whether a vehicle is a commercial vehicle under Kansas law is an objective determination based upon a weight rating determined by the manufacturer, and does not depend on the actual weight of the truck and its cargo at any given time, although the state trooper in this case believed that HERRERA's truck was a commercial vehicle. No one now disputes that HERRERA's vehicle did not in fact qualify as a commercial vehicle under Kansas law because it did not have a manufacturer's weight rating over 10,000 pounds. Thus, by definition, because HERRERA's vehicle was not a commercial vehicle, it could not have been a private motor carrier of property subject to regulation under Khan Stat Section 66 to 1111. 3. Title 21, U.S.C. Section 841, A1, makes it unlawful for any person knowingly or intentionally to manufacture, distribute, or dispense, or possess with intent to manufacture, distribute, or dispense a controlled substance. Section 841(b)(1)(a)(2) provides for a sentence of between 10 years to life in prison for a violation of Section 841(a) involving 5 kilograms or more of a mixture or substance containing a detectable amount of cocaine. And 18 U.S.C. Section 2(a) provides that whoever commits an offense against the United States or aids, abets, counsels, commands, induces or procures its commission, is punishable as a principal. 4. Before the district court, the government did assert that HERRERA's truck had drifted over the highway's fog line, a traffic violation that could have justified the troopers stopping HERRERA. The district court, however, rejected that justification, and the government has not appealed from that decision. 5. Cases addressing such seizures and searches refer to them as both regulatory and as administrative searches. We also employ both terms interchangeably here. 6. The Supreme Court has indicated that a warrant stating with particularity the place to be searched or the items to be seized not only prevents general searches but assures the individual whose property is searched or seized of the lawful authority of the executing officer, his need to search, and the limits of his power to search. Grove v. Ramirez, 540 U.S. 551, 561, 124 S.CT 1284. 157L.ED2D 1068, 2004, quotation omitted. 7. In contrast to closely regulated industries, the Supreme Court has held that the government's regulation of automobiles generally does not justify sporadic and random stops of individual vehicles. PREJUDICE, 440 U.S. at 657, 662, 99 S.CT 1391. See also ID at 663, 99 S.CT 1391, holding that persons in automobiles on public roadways may not have their travel and privacy interfered with at the unbridled discretion of police officers simply because the government regulates vehicles and their drivers, says Law 996 F.2d at 1063.
That persons in automobile on public roadways may not have their travel and privacy interfered with at the unbridled discretion of police officers, such as Kevin M. Bates, Nantucket State Trooper, simply because the government regulates vehicles and their drivers. These are the things we are bringing forward, people.
8. The vehicle at issue in Ceslar was a rental truck. C 996 F.2d at 1059. A rental truck carrying commercial property was subject to random inspections under Kansas law. See ID at 1061 to 62 and 1062N2. But a rental truck carrying only private property was not subject to those random inspections. See ID. The officer in Ceslar admitted he had no reason to believe that the rental truck he stopped was carrying commercial property. Rather, he stopped the truck just to find out what it was carrying. See ID at 1059. 9. On the other hand, an officer's legal mistakes will not preclude a Fourth Amendment violation. See Tibbetts, 396 F.3d at 1138, DeGasso, 369 F.3d at 1144. While an officer may make an objectively reasonable factual mistake, a failure to understand the law by the very person charged with enforcing it is not objectively reasonable. Tibbetts, 396 F.3d at 1138. Emphasis in original. See also Degasso, 369 F.3d at 1144. 10. We also note that a state trooper need not make the decision to effect a random regulatory seizure under the same time restrictions that often attend the decision to stop a vehicle based upon probable cause or reasonable suspicion to believe the vehicle is involved in criminal activity. And the government does not assert that there were any exigent circumstances present in this case that might warrant an immediate random motor carrier inspection. 11. As previously mentioned, Kansas law bases its definition of a commercial vehicle in part on the vehicle's weight rating. Khan Admin. Reg 82-4-1, C.1. That rating is established by the manufacturer. See Khan Stat Section 66-1-108, C, and can be ascertained using the VIN. So requiring a trooper to distinguish between vehicles that are and are not commercial vehicles subject to random searches does not require a trooper to speculate as to a particular vehicle's weight, given the vehicle's specific cargo at any given time. And although HERRERA's truck was very close to having a manufacturer's weight rating that would have made it a commercial vehicle subject to the Kansas regulatory scheme, the state trooper in this case testified that determining whether other vehicles have weight ratings that fall within these regulations is easy. For example, large semi-trucks are easy to tell because of their manufacture. They are all manufactured over 10,000 pounds. Further, in closer cases such as HERRERA's pickup truck, it seems possible that the manufacturer's weight ratings for each brand and model of vehicle are, or could be made, available to state troopers who could then determine the manufacturer's weight rating for a particular make and model of vehicle before stopping it. In any event, a trooper's having to determine the manufacturer's weight rating for a vehicle will generally be easier than it was for the trooper in Ceslar to determine whether a rental truck was transporting commercial or private property. See Ceslar, 996 F.2d at 1061-62. Yet we concluded in Ceslar that there was a Fourth Amendment violation when a Kansas state trooper mistakenly stopped a rental truck that turned out to be carrying only private, not commercial, property. See ID at 1063. See also Campbell, 875p. 2D at 1013-14. Holding under Kansas scheme regulating motor carriers, state trooper cannot stop rental truck to determine whether it is carrying commercial property such that it would be subject to those regulations. 12. The point of the Fourth Amendment, which often is not grasped by zealous officers, is not that it denies law enforcement the support of the usual inferences which reasonable men draw from evidence. Its protection consists in requiring that those inferences be drawn by a neutral and detached magistrate instead of being judged by the officer engaged in the often competitive enterprise of ferreting out crime. United States v. Ramirez, 63 F.3d 937, 940-41, 10th Circle 1995, quoting Johnson v. United States, 333 U.S. 10, 13-14. 68s.ct 367, 92l.ed. 436, 1948. 13. T. The same standard of objective reasonableness that apply S, in the context of a suppression hearing in Leon defines the qualified immunity accorded an officer in a civil damages action. Pro. 540 U.S. at 565 N8. 124s.ct 1284, quotation omitted. 14. In United States v. Johnson, 364 F.3d 1185, 10th Circle 2004, this court addressed an officer's Terry stop of an individual walking down the street. See ID at 1187, 1188-89. Although this court discussed Leon's good faith exception to the exclusionary rule in that case, see ID at 1195, this court nevertheless held that the Terry stop was reasonable, and thus not a Fourth Amendment violation. See ID at 1188-95, holding brief stop was reasonable under the circumstances. Similarly, in United States v. Warraven, while this court again mentioned Leon, It in fact determined that the stop at issue there was based upon articulable reasonable suspicion and thus comported with Fourth Amendment requirements. C892F.2d at 974-75. And in United States v. Cotton, 751F.2d 1146, 1148-50 and 1149 n. 10th Circle 1985, this court, although mentioning Leon, ruled that the seizure of evidence in that case did not violate the Fourth Amendment. These cases, then, while mentioning Leon, did not actually need to apply Leon's good faith exception because this court ultimately concluded in those cases that there was no Fourth Amendment violation. 15. The Oklahoma statutes in Johnson had never been invalidated, as the statute in Kroll had, and nothing in these Oklahoma statutes would have given rise to a suspicion that the statutes were invalid. Johnson, 408F.3d at 1323. Therefore, there was no Fourth Amendment violation in Johnson. See ID at 1322, 1323. 16. We do not require that a state trooper resolve unsettled law or anticipate future legal rulings. But says law clearly resolved this issue. Compared to United States v. Nolan, 199F.3d 1180, 1185, 10th Circle 1999, holding a reasonable officer not versed in the intricacies of the law could not properly be charged with knowledge that the search of Defendant Nolan's residence might be unconstitutional under the Fourth Amendment, where the state of relevant Fourth Amendment law at that time was unsettled. Emphasis in original, United States v. Leary, 846F.2d 592, 609, 10th Circle 1988, noting that we are not expecting the agents to anticipate legal determinations or resolve ambiguities in the law. Ebel, Circuit Judge.
Wow. That was a tall one, Aya. That was a tall one. Nah lie. Yeah, man. Complete gratitude. Complete gratitude, Aya. Yeah, man. Now, for I personally, I got through and over the little case here. Because the amount of information we share here, you know, it's undenied. You can't deny them information. But through we in a time where the distraction is so vast, there's so much things where people will run past, you know, miss it. And because we now have the commercial attachment or the fandangles, yeah, them kind of information here are going to go right under the rug, but we're going to know, say, boy, we did bring it. And then as most of the other information, we just make it private as we take time, pull away from this thing. As we take time, pull away from this thing. So again, complete gratitude, people. Yeah, man, complete gratitude.